So once WA reaches that 80% fully vaccinated point in that first week of December, so their trajectory indicates, what if someone like Clive Palmer takes the state to the High Court again to force the Premier to reopen? Now, the Attorney-General, Michaelia Cash, warned during the week that the Premier's powers to keep borders shut could diminish with that level of vaccination. The High Court last year ruled against Palmer's challenge on the grounds it was a proportionate public health response to the pandemic, given there were no available treatments or vaccines for coronavirus. Now, the conditions will have changed dramatically by December 7. Constitutional law expert Greg Craven, he's a former Victorian Crown Counsel and former Vice-Chancellor of the Australian Catholic University. He joins us now. Greg Craven, thank you very much for your time.
No problems.
Is the Attorney-General right? And if you agree with her, why?
Look, she's right, and the reason I agree with her is for reasons of law, not politics. One of the most important sections in our Constitution is Section 92. It says trade, commerce and intercourse between the states shall be absolutely free. Now, intercourse is the most giggled about word in our Constitution, but it actually means travel, communication, movement between the states. Now, the way the High Court interprets that is that you can only restrict movement if that's reasonable in proportion to the particular situation that you find. Now, the High Court found, I think wrongly, last time, that there was a balance between Premier McGowan, Western Australia's restrictions and the situation. But of course, as vaccines rise, as plans become clearer, as modelling becomes clearer, it becomes harder and harder and harder to show that your restrictions are reasonable and proportionate. And at some point, they collapse in the face of Section 92. Now, that point clearly is coming closer.
So just tell me, though, you mentioned there that the High Court got the refusal to grant Clive Palmer his challenge and they were wrong. Are you saying the High Court got it wrong last time?
Absolutely. It's the job of constitutional lawyers to regularly say the High Court got it wrong. But I think in the constitutional law community, which you would understand is not a big one or a fun one, it was generally expected that the decision would go the other way, simply because the restrictions were so tough that it would be hard to argue that they were proportionate. I think the reality, clearly, the mix between politics and law for Premier McGowan is the clock's ticking. As the vaccinations go up, as the modelling becomes clearer, the chance of resisting another challenge on Section 92 becomes harder. And I think the High Court might well be looking back at their last decision and thinking, gee, I wonder if this was one of our best.
Interesting. Now, they're due to hit that 80% fully vaccinated mark on December 7. They'll hit the 70% in November. When would be the best time to mount a High Court challenge, do you think? At 70% maybe?
It's a question of tactics. I mean, mounting a High Court challenge itself actually does something. So if I were, interested in this politically, which I'm not, or in business, which I'm not, I would be quite tempted to start mounting a challenge now with a view to getting it up and being heard around about the 70 to 80, because it will put pressure on Western Australia. And I would say one thing about Western Australia, because I lived there for 12 years. Western Australia does have real challenges in a lot of ways because it is so big and because it's sparse and because it's got large numbers of Indigenous people. It's stretched out 8 times the size of Mars. So there are challenges that they face that aren't faced in my home state of Victoria. But inexorably, there will be a point where a challenge to the High Court will succeed because things have got better and the ratio between reasonableness and risk has changed.
And it would be handy to bring in one of the senior professors from the Doherty Institute as a witness too, wouldn't it?
Well, yes, I think that's right. The challenge, of course, is that the High Court is not brilliant on evidence. It's very good on law. It's not like a magistrate's court where if you're caught driving a car without a licence, you can line witnesses up. But yes, you would have that type of evidence put forward. That's one of the things about Section 92 cases. They actually work on a whole lot of regulatory and economic evidence. And at the point that the High Court said, well, frankly, these restrictions just don't match the situation, they would make probably an order in the nature of a declaration declaring that the restrictions of WA or any other state, it's not just WA, were inconsistent with the Constitution. At that point, they would become invalid and not law. So in a lot of ways, if you were in that situation as a state, and I'm sure this is what's happening, you would be preparing with that eventuality in mind so that you would be able to moderate your own exit from an existing strategy before it got struck down by law.
Okay, one last question. The slow cogs of the court system are well known. Because a challenge like this may not be waged in the High Court until December, we know the court process has a long break over the Christmas period. When would they preside and when would they rule on a challenge such as that? Would it take forever?
No, look, the High Court can be silent on a wet week, but my feeling would be that particularly if it is feeling a certain amount of regret about the first decision, and particularly given that even the High Court understands what COVID is and what a crashing economy sounds like, I think it would move quickly. I've heard the alternate suggestion that the Commonwealth would legislate. I think that's silly because first you'd have a parliamentary process that would draw it out, then you'd have a challenge to the legislation when it was made, and you'd simply have more court cases. It's better, I think, if you want to bring this thing down, bring it to a head. If I were doing it, I'd go sooner rather than later.
Greg Craven, thank you very much for that insight. Superb. Thank you for your time.